Good evening, everyone. Welcome to the special immigration show brought to you by Sakshi TV. My name is Ranjit. We are here today with the prominent attorney Sheela Murthy to discuss latest updates and also about the US Citizenship Act. You can call the numbers displayed on the screen and ask any question related to immigration, and our attorney will be glad to answer. We'll start taking calls in a few minutes. Before starting the show, I would like to repeat the disclaimer. Please note this show does not provide any legal advice. It is general in nature and it is only for informational purposes. Sakshi TV news and agents are not responsible in any way for your actions. Please use the information at your own risk. You all know about Ms. Murthy. She's founder and president of the Murthy Law Firm and Harvard Law School graduate. Also, she's the one behind Murthy.com. Before getting into the show, I would like Ms. Murthy to give a brief introduction and then we'll take it from there.
Thank you so much, Ranjit. Welcome, everybody. Thank you so much for joining us today. As Ranjit correctly pointed out, Murthy.com was started 26 years ago, mainly to help educate, enlighten, and empower those who are going through the US immigration process so you don't feel alone and left out. Our goal is to continue to support you and help you and your family members through what I think is a complex, difficult, and ever-changing journey of immigration. Just right before we were preparing for this, Ranjit and I were talking about how you think it's one thing and the rules change, the laws change, the regulations change. So we certainly look forward to continuing to help you. You can contact us at law@murthy.com. Go to website www.murthy.com or call us at our phone number if some people prefer phone, FaceTime, whatever, anything, but just call or send us an email, law@murthy, or call us at 410-356-5440 to schedule an appointment to speak with one of our attorneys or to help you in any other way. I also want to quickly plug this beautiful book, which is empowering, educational, interesting stories about many of you, your immigrants, your lives, your stories, that a beautiful author has written and published by HarperCollins, talking about immigrants and their journey and the stories and the stuff over the years that some of you may find touching and connect with your own family. Thank you, Ranjit. And now we're open for questions or to discuss the Citizenship Act of 2021.
We have a caller. Let's take the call. We have a caller from Texas. Hi, welcome to the show. Please go ahead and ask your question.
Hi. So I have a copy of RFE notice and an approved but unused H1 from 2009 timeframe. Though I do not have the H1 approval copy in hand, the RFE copy seems that I got seems legitimate with my name mentioned and the reason stated for the RFE, etc. Now, after 12 years, USCIS website still shows that my H1 from 2009 timeframe is approved, meaning that the H1 was not withdrawn. So recently I have requested for Freedom of Information Act for my H1B approval copy and waiting for the results. Meanwhile, I'm getting an offer with a good company for 18 months contracting position. With this, I also have a I-140 petition through my L-1B visa employment recently. So is there any legal way to take this employment, the new employment forward, the contracting position for the 18 months? Say, can I take this offer?
When your prior H-1B petition was approved, was it approved for change of status within the United States, or were you outside and you never stepped into the United States and never got a visa stamp in your passport?
I stepped out of the United States and it was not stamped.
So you were in the US when it got approved, but you did not go abroad and apply for the visa, or you never had entered the US when your H1 was approved?
I never entered a visa. I never entered US.
So the USCIS position is, because the statute, if you look at the law that actually says your H1 petition, either your change of status or you should have obtained a visa stamp in your passport, that's the strict reading of the law that allows you to continue to extend your H1B status based on an I-140 approval. So if you never entered the US on H1 status, you never applied for a visa stamp in your passport and never got an H1 visa stamp, you don't have an I-94 card attached to your H1B approval notice, The USCIS position is generally that you are not eligible for the H1 in the future, even based on an I-140 approval. Some people have tried it, it has worked. Some have tried it and it hasn't worked. The USCIS, at least in the recent past, has been pushing back, but the statute that allows you to extend it clearly says you should have been in H-1B status or obtained a visa, which in your case, it appears neither happened. So the risk is higher. If you want to give it a shot, you can, but the employer may be hesitant to spend thousands and thousands of dollars paying filing fees, legal fees, processing fees, only to get a denial in a case such as yours.
I hope that answered the question. And we have another caller, Ankit. Hi, Ankit. Welcome to the show. Please go ahead and ask your question.
Hi, Attorney Murthy. My name is Ankit. So my question to you is, like, my previous US employer did not generate my payroll for like 3 months when I was waiting for joining at the client location. So currently I'm in India, basically. So will this cause any issue for my visa stamping?
So this was when you were physically in the United States, that you were not paid a salary by the employer, and now you've
yeah,
gone
so
back
this
to
was
India?
Yeah, so this was in 2015, like around 6 years back.
Oh.
Then as soon as I got a project, then my payroll was started at the same time. Then I had never issues with the payroll. So I was in consistent payroll since 2015. So it was just a matter of 3 months when I was waiting for the joining due to some like compliance and audit issues, and the position was on hold. So my employer did not generate the payroll at that time. And that was my initial H-1B when I traveled for the first time.
Okay. So in general, the consular officers don't go back 5 or 6 years to somebody who has not maintained status. They will ask for the past 1 or 2 years, 6 months, 1 year, 2 years, 3 years, but I've not generally found them going back 6 years unless there's some criminal or other type of fraud related issues. Then there's no time limit on how many years, even decades, that they can go back on Ankit. But in a situation like this, it hopefully should not pose to be a problem in applying for the visa at the consulate. Provide all the information, the documents, everything to show that you're eligible for your H-1B visa stamping. Show that your status, show the prior, because they may ask for W-2s, they may ask for year-end proof that you've been paid the prevailing wage as required on the H-1B petition. And once you do that, hopefully you will find that your visa should be granted unless there is some other issue that can come up. But this issue from 5 or 6 years ago, from 2014, 2015, should not hopefully come up, because generally we have not found it to be a problem. Good luck, Ankit, with getting your visa.
Okay, before that, okay, let's start with, let's discuss about the US Citizenship Act that's just introduced in House and Senate. Can you give a brief introduction and let us know how it's going to help and solve the backlog issues, and what are the good things and bad things that you think, and what are the chances, and how it's going to be?
Ranjit, that's such a loaded question, as you well know. We could spend a whole day, 8 hours, talking about the Citizenship Act of 2021, introduced actually by President Biden on the very first day, on January 20th, when he came into office. But finally, both the senators have introduced it in the House and in the Senate. But from an employment-based immigration law point of view, it's got some very, very good and helpful provisions. Of course, it increases the number of immigrant visas from 140,000 to 170,000. Second, it actually does not include spouses and children in the count of people. So basically, that's almost doubling or making it triple the number of immigrant visas. It greatly allows expansion this will help, obviously, people from India primarily, and then China and maybe Philippines to some extent, but India and China primarily in the employment-based sector. It also talks about H-4 visa applicants not only being limited to the spouses, but also allowing children to be eligible for H-4 EADs, allowing them to continue to work as long as the H-4 extension is filed prior to the current H-4 status expiring, because now we are seeing waiting times from 8 to 13 months on average, including as long as up to 2 years, I believe, in the California Service Center, in some cases for H-4 EADs, which was really a fiasco. It's a mockery of a government organization that is purposefully delaying the ability for people to continue to work because they couldn't change the law in the prior administration, so they tried to work it around this way. And another very, very helpful issue is that it will allow the recapture of unused immigrant visa numbers from 1992 until 2020, for almost 30 years, 28 years, to be put back into the system, because we have lost on an average of about 7,000 immigrant visa numbers each year. So we should be able to recoup or get back 220,000 immigrant visa numbers approximately, which will help with a lot of the backlog. And also the bill talks about, instead of waiting, because as we know, Indians, nationals and some Chinese, but primarily Indians, we may have to wait between 10 years and 20, 30, 40, 100 years for the immigrant visa based on the 7% per country limit. They plan to eliminate the per country quota limits altogether. And they wanted to introduce, in the bill also mentions that if you've been waiting for 10 years with an immigrant visa petition approved, then you should be eligible to get your green card right away. And of course, the very important point, which is affecting a lot of parents and making them very distraught, is children who have been waiting 5, 10, 15 years, came up when they were 4 or 5 years old, are now potentially aged out and no longer eligible to get the green card with the parents. The bill makes it, allows that from the date the petition, the green card was filed, or the 485 was filed, the age of the child is frozen, so that under that bill, children will be protected and not have to panic about, oh my God, I'm not going to get the green card with my other brothers and sisters who were lucky to be born a couple years later, or whatever. So that's the good, many, many good things for employment-based immigration. A couple of the things that are not great, of course, are the fact that even though Biden made it clear that he didn't want another president who was anti-immigration to introduce a bill or law, or do things like was done in the prior Trump administration, it actually says that they can stop people from extending or staying or entering the country on non-immigrant or immigrant visas if there are high levels of unemployment. And those are not defined as what that means. So a president like the former president, who was in an all-out war against immigrants, literally could make up stuff, create those proclamations or bans to prevent people from coming in. We don't know what this could mean for somebody that's anti-immigrant. And the next thing that was bad, of course, was what the Trump administration had introduced before, which was the issue of the very high salaries for H-1B workers, which has now been pushed, as we all know, through until December 31st of 2021. The concern is that if that is left to be allowed in the bill, or to encourage the highest level salaries, then fresh graduates, international students, all of them will no longer be eligible to get H-1Bs or stay in this country, which will pretty much dry up the pipeline. One very good plus point, so we've gone through a lot of plus points, couple minus points, but one very good plus point was STEM, science, technology, engineering, and math. PhD graduates would not be counted in the immigrant visa quota numbers at all in the 170,000 new proposal under the bill. And as I said, spouses and children will be exempt. So there's lots and lots of wonderful, wonderful things if it passes. But we don't expect the bill to become passed as it is to become the law. We expect that some portions of it could get passed, that it may, and President Biden has made it clear that he would be willing to consider it in piecemeal fashion. It doesn't have to be all or nothing kind of proposal, because they expect some pushback from the Republicans. Even though Republicans have traditionally been pro-business and pro-employment immigration, because they don't want Biden as a Democrat to get the credit for an all-sweeping and solving the problem of immigration, because then it would look like the Democrats are winning and not the Republicans. So the partisan warfare is probably the reason that some parts of the bill may not get passed.
Yeah, looks like that. Let's hope and pray that everything goes fine. Probably there would be negotiations, as the administration already said they are open for negotiation. So let's hope they negotiate and get something passed soon. Before we get into the in detail about it, we have a caller, Ms. Sheela. Let's take the call and then we'll take it from there. Hi, Vijaya from California. Please go ahead and ask your question.
Yeah, thank you. Hi, my name is Vijaya. Hi, Sheela Murthy. I have a question. I'm currently on a H4 visa and my application is pending for the past 8 months. I haven't received my biometrics as well. Of course, I am not able to work because of that issue. I have an old H1 from which was back in 2012. It's more than 6 years. If I can find an employer, is there a possibility that I could use my old H1 for as like a H4 to H1 transfer? Is that possible still? Because I'm hearing like multiple things saying like if it is above like more than 4 years or 6 years, we cannot use that H1. But can we use that?
Yeah, so it used to be there was a rule about the 4 years or 6 years before that, Vijaya, but now they're not asking and they're not requiring that. So it depends on how many years of the 6 years you had used up, Vijaya. So if you had used up all 6 years and there was no I-140 petition approval in your case, then you will be out of luck. But if you had, for example, only used 2 or 3 out of the 6 years, for example, then you would be able to use the balance of the 3 years. So if you had used up 3 years of your H1 6 or 7 or 8 years ago, you still have 3 years left. You can show the prior H1B approval, show the unused time that you have of 3 years, for example, in this example, and then you would be allowed to file a change of status from H4 to H1B. However, you cannot start working based on simply filing the petition, the change of employer, the change or with the H1B petition. You would actually need that petition to be approved with the I-94 card attached to it, meaning that the change of status has to be approved by the USCIS. But of course, the good news, as you know, is that premium processing is available right now. So if you're able to file it, you're able to get it approved, then you should be able to start working on it. The difference, of course, from the first caller that called in earlier today and you would be that you were actually working on H-1B status more than 6 years ago with this H-1B employer, correct?
Different employer. I worked like 6 years ago with a different employer on H1. Right now, I'm on H1 with a different employer. So I'm asking my current employer to use my old H1, which I have used for 5 years and no I-140 being filed. So I was expecting the new employer should be able to do my I-140 and all because I'm already in my 6th year beginning.
Okay, so you will only get H-1B for 1 year if you used up 5 years of your prior H-1B. And it takes, as you know, more than 1 year to file and get, it takes almost about a year, 7, 6, 8 months, 9 months to file the perm. It takes 3, 4 months if you're lucky to get the perm approval and then file your I-140. So you'll get 1 year, but that might be all you need because if it's already been 8 months that your H4 EAD is pending, then you get this H-1B, you get this approved, and when you hopefully get the 3-year H-4 EAD approval, when this 1 year gets over, you then continue to work on the H-4 EAD. But I'm sure you have your lawyer that you're discussing the different options and risks and pros and cons, because as Ranjit announced at the very start of this discussion, by law, we can't get into case-specific details, but it sounds like you should be able to get the 1 year, and then hopefully, if your spouse got the 3-year H-1B approval and you can get the 3-year H-4 approval with the 3-year H-4 EAD card, you should hopefully be able to switch from H-1B under premium processing for 1 year and then get the rest of the 2 years on H-4 EAD. Good luck, Vijaya.
Okay, there is one question and then one rumor that's going around. A lot of people say this is about the adjustment of status. I would like to clear once and for all. So a lot of people are saying about this downgrade. There are two ways of filing a downgrade, like a new and amendment. Could you please explain the difference as well? And let's say again the dates go back, or in this previous date, like EB2 gets current. So there's a process called interfiling. Could you also explain a little bit about that? So it's clear. A lot of people say the interfiling is not possible when a downgrade is done, even as a new. There is a lot of misconception. Could you please clear that around?
So the thing is, the law itself, there's nothing very like specific which says you can or cannot, which is why you are allowed to do downgrades are permissible. At the Murthy law firm, we generally tend to file them as amendments, not as new cases, because you already have an EB2 approval, for example. You want to amend that to an EB3 downgrade case. So we file that. And then if the priority date in EB3 is current, but not in EB2, as happened in October and now, that is happening because EB3 is a little bit ahead by a few months compared to EB2 in the news, in the visa bulletin that just came out for March of 2021, then you could do the EB2 to EB3 downgrade. You could file the I-485 concurrently if the EB3 priority date is current. The risk, of course, is that if for some reason it gets denied, the I-140 downgrade gets denied for any reason, then obviously the 485, the EAD, and the AP would all get denied as well. Some people file it as a new case. I don't know what a new case really means because it really should, in my opinion, ideally be simply as an amendment, though a lot of people say H-1B, I'm doing a change of employer or a transfer, but what they actually mean, it is legally a new H-1 petition each time you change an employer. So similarly, each time you file an EB2 to EB3 downgrade case, it is an amendment of a previously approved case. So I don't know what, other than using a misnomer or an incorrect terminology, it is the same thing because you're basically asking for a new classification of a previously approved I-140 petition. So as long as that priority date, either in EB2 or EB3 is current, you file the 485, you can do it concurrently. And if everything gets approved, if the I-140 gets approved, then hopefully your 485 or EAD or AP first. And if the priority dates are current for the final action dates, then your green card, your 485 could also get approved.
Okay, but in this case, let's say, yeah, let's EB3 was in filing dates, not in final action dates, and later, let's say EB2 final action date becomes current. Can they interfile in this case of amendment?
So if they file the EB3 because it's current in date of filing today, and then the final action date in EB2 becomes current in the future, it's better. So if they've done an amendment of the previously approved case, so they could do, if they've done it as an amendment, you're now saying, whoa, 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 please don't worry. I want to no longer pursue that amendment, but I wish to pursue the EB2. Attached is the EB2 approval previously approved by USCIS. Please now approve the I-485 based on the EB2 priority date being current. It potentially could and should be possible because those dates, final action dates, are current right now. The question is, because of that prior amendment, you would also need to say, I no longer wish to pursue the amendment to the EB3 downgrade, because you no longer need that in order for your I-485 to finally get approved based on the final action dates in EB2 being current.
Caller Harika from Dallas. Let's take the call. Hi, Harika. Welcome to the show. Please go ahead and ask your question.
Hello. Hi. So my question
Harika.
here is, hi. So my question here is, I have my green card filed, but it is filed as a future employment with a different company who is not holding my H1 right now. It's a sister company of my current employer, and they have filed as a future employment. Do you see any concern with that, like as a future employment?
So Harika, what we find is when people do file the green card based on the job offer being a future job offer and not based on current job employment, a lot of times people say, well, I don't need to join that employer ever, right? Because it was anyway a future job offer. So if I get my green card through company A, why should I join company B, even if they filed my green card? And the answer is no, you don't want to take a risk because there's potential fraud and misrepresentation. According to the USCIS and Department of Homeland Security, if a person never joins the employer for which you promised under oath penalty of perjury to join that employer. The employer promised to give you a full-time job. So we tell people, if you've already filed, if you filed your perm in I-140 and now you're filing your 485, it's a good idea to join that employer, because if nothing else, you can also take advantage of AC-21 portability by showing that I worked in that job for that employer 180 days after the I-140 approval and the 485 was pending. And then if you want to go back either to the first company A, whom you have always been working with, or continue with company B, because that was the employer that promised to file the future green card case for you, that would be much safer. A lot of people think, oh, it's a future job, so I don't ever have to work with that employer. And that risk is not worth taking, because in the future, when you try to apply for your citizenship, Harika, it could come back to haunt you, where they would say you did not work for the employer that you promised under oath that you would work for. So be very careful with situations based on future employment.
Okay, just adding, continuation of the last question Harika asked. What do you think the situation is? Let's say they file 485, and do they have to join before filing it, or at least let's say after filing an EAD, can they join after getting an EAD? Now that way it's kind of safer.
Sure. Join, because ultimately when the I-485 is either going to be approved, and either they issue, sometimes if the time is more than a few months, they often will issue another RFE saying, give us the latest employer letter confirming where you're working and what you're doing. And so when the priority dates keep moving, you ultimately get the EAD, you then join that future job, so that when they ask for proof of where you're working and what you're doing, you can show that, yes, I am with the green card sponsoring employer as I had promised that I would join, and here's my proof, and here's my pay stubs, and here's the proof that I'm working with that company or that employer, as opposed to, well, I haven't started, because people say, well, I'll join after I get my green card, and the USCIS says, no, we won't approve your 485 till you join that employer. So it's like the chicken and the egg, which comes first, right? You are saying this and they're saying this, and nobody does it. In the end, we need the green card more than they need you to stay. So it's wiser, I think, to join the employer, the future employer, before the 485 can be approved, so that there's no question of fraud or misrepresentation in the future when applying for citizenship.
So got it. So it's always very good to join at least before the green card is approved. So approving after the EAD approval, it makes sense, because there's a lot of opportunity at that point of time. Using the EAD, they can get it. So thanks Harika. We have another caller, Chuck from Chicago. We'll take this call, the last call. Hi Chuck, welcome to the show. Please go ahead and ask your question.
Hey, I'm currently in the H-1B visa, and I applied for the 485, and I received the EAD advance parole card. And for a family emergency, I'm traveling this Friday. So, and I don't have the H-1B visa stamped on my passport. So, but I was able to book the slots in the U.S. consulate in India. So, I am in a kind of doubt whether I should go for stamping and coming back in the port of entry, whether I should use the advance parole or the H-1B visa. Which one will be good for my future use? And for example, if I use the advance parole for some reason, and if something happens, and can I go back India and then use the H-1B extension and get again stamped and then come back actually?
So Chuck, just so you know, you can actually come back if you wish on the advance parole. The 485 will continue processing, and your employer, believe it or not, can actually continue to file an H-1B extension of status for you, even if you have re-entered on the advance parole. At least that's the position according to the USCIS policy guidance and interpretations and what we have seen. If you are still working for the same H-1B employer, you can actually extend the H-1B, even if you have chosen to re-enter on the advanced parole or the EAD advanced parole combo card. So which is better? Sometimes people say, well, I don't get the H-1, I'm stuck, there's not an emergency, I don't want to travel, there's backups, there's backlogs, risk 221G, at consulate, all of those. So people just prefer coming back on the advanced parole. Some people say, no, I want to come back on H-1B and I want to renew my advanced parole. So it's whatever makes you comfortable. Once you use the advanced parole, you can continue to stay with the H-1 employer and renew H-1s, or you can use the EAD card to work in the future with the same employer or with a future employer. I hope that helps you, and I hope whatever family emergency you're dealing with, Chalk, that makes you go to on Friday works out for you, and that whoever, if it's somebody, an ill relative, I hope that they feel better.
Yeah, Ms. Murthy, we are towards the end of the show. And again, thanks for your time. Thanks for all the calls and watching the show. It was a great session with interesting topics. Please call in every Tuesday, at 1 p.m. EST to watch special immigration show. Again, it's every Tuesday, 1 p.m. EST on Sakshi TV. This is Ranjit signing off. Thanks, Ms. Murthy.